FSU replies to the request to stay discovery in Florida.
The ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Hey, welcome back to the mountain. I am JY. This is my good friend Steve. Steve, we're going to do another episode on FSU. Probably going to be the only one we do this week, at least, even no matter what happens. The rest of the week just got some other things we want to get to, but we do want to talk about this response from FSU regarding the ACC's motion to stay discovery in Florida. And there's a couple things here I really liked. Some of it actually gives more detail to some of the comments and reporting and items we talked about with the hearing, and gives a little more of that backstory as to the interactions with the ACC and how they got to this whole idea of materiality or not materiality in order to get a vote for litigation. But with that, I want to just say we did do a poll that I put out on Saturday. We had just over 100 people vote on this poll at this point. We have 53 people saying that there's going to be a motion to either dismiss or stay because of standing. That's broken down 17% because of materiality. 36% think it's because of that retroactive vote that you really kind of were talking about. About 25% of the people said that there is not going to be a stay or a dismissal here in North Carolina. So it was pretty interesting. Not scientific at all, but it was interesting to see where people were at on this.
I'm going to guess there was an oversampling of Florida State fans on that.
I would assume so, yes. Yeah. But anyway, not... Surprisingly, the smallest number was on the sovereign immunity piece. Yeah. That kind of actually surprised me. So there's more in the rightness side, which you and I think is completely a dead issue,
right,
than there even was on the sovereign immunity side. So anyway, with that, at the end of this, I also want to get into a little bit more about the motion to seal. I had another conversation with our in-house counsel here for the Big Mountain. Again, he is an attorney, a contract attorney, just as any attorney, but actually one that deals in contracts. I want to get to that. And I did finally hear back from the AG office in Florida regarding her request way back in the beginning of January. So we're going to talk about that at the end, but let's start off and dive in to this response to the ACC's motion to stay discovery. I want to say these are very procedural motions. Like, yes, there's more data here. I know there was some big headlines, at least from those that are covering this on YouTube and Twitter, of things they wanted to pull out, and we're going to get into that. But this is not the case. What we're doing right now, we're not into the case. This is just motions to dismiss or stay certain things. And again, early on, we've said this before, but I want to remind everybody, especially if they're new, all of these filings are all about venue and jurisdiction. Who's going to hear these cases first and second, or as you've been saying, potentially simultaneously. But even if you get the leg up and they start just before the other one, you're still starting to set that precedent. Yeah. It's all about the venue and jurisdiction right here. FSU starts out by saying that this motion should be denied, this motion by the ACC, in order to get to the truth. And that's what they kind of lay out. They really lay out in this that the ACC's being deceitful, that they're not being truthful, that they're hiding things. Again, this is from the FSU side, and we're going to get into some of that. The ACC argues that the principle of priority requires the Florida proceeding to be halted pending the disposition in the North Carolina action. Again, a lot of their eggs in that North Carolina basket. They get into, they have two main points. One they call the taking, and the other they call the mischief, the deceit, right? And three pieces with that mischief. In terms of the taking, FSU describes what is to be taken by the ACC. They state that the property here is the media rights of FSU. They then say that the ACC provided the where, that being the home games of FSU, and that the ACC objective is to take that Florida property for the next dozen years after FSU exits the ACC and ceases to be a conference institution. FSU then goes on to this mischief, and that's where things get a little more salacious. That's going to be my word. You brought that up a week or two ago. This is where we get some of the salaciousness and really the big headlines that some people brought out of this. Three main areas. The first one here is the commercially reasonable efforts clause that was in, or that is in, the ESPN agreements with the ACC. FSU points to an affidavit from the ACC Secretary and Deputy Commissioner that proves the ACC did not vote to approve the initial litigation. I think we already knew that. We certainly knew that from the hearing that just happened. They literally said, yeah, we didn't take a vote. Like, that's not new news at this point. But I will say the next couple things I'm going to go over with affidavits and things, again, lay out exactly what happened with the ACC and why they got to where they got to in terms of why they didn't vote and the materiality piece of this. But FSU, of course, is going to call this, mischief and how they handled things. So, going on. This affidavit does confirm that a vote was obtained then on January 12th that approved the amended filing and was inclusive of the original claims from December 21st, 2023. It also said that this will be approved in the minutes on March 19th. So I saw a little bit of pushback and saying there's no justification to this. You're saying there's an affidavit that you're saying this, but we have not received minutes. Being on a public entity side of things, going through that, yes, they're minutes, but they don't approve those minutes until the next meeting, and then they become public. So that makes complete sense for people that maybe aren't in the public realm of how they do things. Minutes aren't really published until they're approved at the next meeting. They say that was on March 19th, so maybe they're out there at this point. I did not look. It then goes on that a response to a Judge Bledsoe request from North Carolina, that there was another affidavit that was provided by James Ryan. He's the chair of the ACC board. He's also the University of Virginia president. That he, in consultation with the ACC's management, authorized the filing of a lawsuit that sought only declaratory relief concerning the validity of the grant of rights. In their opinions, this did not require authorization of the board because this lawsuit did not initiate material litigation. It sought only to defend and preserve the agreement. Again, this is exactly what we heard in that hearing. We're just seeing some documents kind of behind the scenes, if you will, of how that all occurred, coming here from James Ryan. In addition, and I feel like this part's important to the reply here by FSU. Under the ESPN agreements, unanimously approved by the conference was obligated to take all commercially reasonable actions necessary to protect the media rights that were provided to ESPN under those agreements. We're going to get to that here a little bit more in a minute, because that's where they kind of poke holes at this to some degree. Judge Ryan went on to say that he spoke with ACC presidents of Duke, Syracuse, Wake Forest, Virginia Tech, and Boston College, and they all agreed, not a vote, but just informal discussions, they all agreed with the interpretation of the ACC bylaws regarding this material litigation, or really lack of a material litigation. He also stated that he presided over this January 12th meeting and that a vote was taken to file the amended complaint, and that was inclusive of the original claims. The vote was needed because the amended complaint had several claims for damages. Now, FSU claims that only limited snippets of this commercially reasonable efforts clause were actually sent out by the ACC. So now, you got to lay all that out so you know where we're at, and most of that we heard again, in the hearing. It's exactly what they said in the hearing. Yep. But here's where you're going to start getting into this mischief, according to FSU. So because only limited snippets, limited parts of this clause were sent out, Judge Bledsoe actually sent an email to the attorneys on both sides saying that the commercially reasonable efforts clause appeared to be a defined term in the agreement, but was not provided. He requested that they provide that definition to the court. Remember, the materiality piece was not a defined piece. So that's what's up for interpretation by both the what we talked about here with Ryan and the presidents and members and the commissioner of the ACC. And if the judge actually thinks, yeah, I agree with you, or I don't, or maybe I don't need to agree with you, it doesn't even matter. That's what the hearing is all about. But he's asking for more of this. So once he sends that email, the ACC then provided this to the court and to FSU. With that definition, FSU states that the definition does not require the ACC to take action. And we've heard that a lot. I mean, the ACC has really said it's threefold now. We talked about the materiality being first, the retroactive approval being second, and really the third thing that we didn't talk about much in the hearing, but they have said it, and Ryan has an affidavit here saying it, that we were required to take action under the ESPN agreement. FSU saying, no, that's not exactly what this says here. Now, can you take action? May you take action? Yes, but they've been posturing, the ACC has been posturing that this is another reason why we didn't need to take a vote, because this agreement says we have to take action. So FSU is saying that's not what this says. And whether I agree or disagree with that, quite frankly, Steve, is somewhat irrelevant.
Yeah.
It frankly gets back to materiality. In my opinion, like, okay, say they didn't, this doesn't hold water in terms of the ESPN agreement. As long as the judge says, yeah, you can define your materiality and I'm not going to judge you on whether or not that was right or not, they're good to go. I mean, as long as the judge does not find this to be a material litigation, agrees with, or at least just says, I'm not getting into that, this part does not matter because it's not a material litigation. But anyway, with that, I'm going to let you speak. We'll get into the second and third items next.
Yeah, I mean, in general, I don't think that there's a lot of new stuff. First of all, going back to the beginning, again, the ACC continues to their main priority is obviously having this in the state of North Carolina. That priority, yep. Back there, they're putting, like you mentioned, they're putting all their eggs in that basket. Which may end up being a very successful strategy, like we've talked about many times. Again, a lot of this we've heard in the state of North Carolina. It's going to be interesting because we'll have a judge in Florida versus a judge in North Carolina to see first of all, what questions they ask. Are they going to ask different questions? And does that really tell us more, or does it tell us anything about how they're going to end up ruling? Mm-hmm. It did strike me as funny. I've been in so many meetings with lawyers going over, contracts, parsing language and contracts, and it just reminded me of the difference of you shall do something, yes. You should do something, you may do something,
may, must,
yes,
all of that,
must,
for sure,
and it's may versus must, and it's amazing that we may have a $500 million lawsuit potentially come down to exactly how the contract was written, if it says shall or should, mm-hmm. or how the judge interprets the language. Maybe it's not as clear as one word. So that's just kind of my thoughts on that, and let's just keep it moving.
That's a perfect point, for sure. I've seen that happen too often, where I read it one way, but is it open to interpretation? Actually, yeah, it kind of is. And I just want to bring this back to the beginning. This isn't about the motion to dismiss right now. This is a motion to stay discovery, or a response to the motion to discovery. And they're bringing this up because they're saying, if you stay discovery, we're only going to get half of a definition, not the full definition. Right. So that's why they say this is important in terms of discovery. We just went through a whole bunch of stuff that really had to do with the motion to dismiss. Mm-hmm. But this response is about discovery right now. So that's why that's important. They also, of course, get into some false claims now that they're being more salacious with this. It wasn't just the facts. It's, I can't believe that Mr. Ryan would make these false statements in an affidavit type of deal. Okay, fine. The next one is, and I'm not going to get into the details of this one, but it was about that extension of the ESPN option for 9 years. They bring that up a little bit. That's actually the smallest portion of this. But again, that's where they're saying mischief occurred. There wasn't a vote. We don't really know what's going on here. You can't stay discovery because there's mischief, at least in our eyes, in FSU eyes. There's mischief occurring. We need to be able to dig into this more. The third item, which they call the most substantial misrepresentation. FSU argues that the ESPN agreements are for the home games played while FSU remains a conference institution. after FSU exits the conference, then it is no longer a conference institution. So that means the ESPN agreements have no application to the disputed property. This is a total copy and paste, or almost a total copy and paste, from the Clemson filing. Yeah. And they actually have snippets of the Clemson filing that they put into this filing. The verbiage is exactly the same that they're using. And this part, to me, it sounds good. It sounds great. If you haven't done the deep dives that we have done, right? We've talked with attorneys. We've read articles from attorneys. We've done deep dives on this in the past. Again, we're not attorneys, but I think over the last 3 or 4 months, Steve, we've done a lot of research on this. It doesn't make us right or wrong, but I want to maybe counter this a little bit and tell our viewers what the grant of rights, again, actually say. So the grant of rights here says, each of the member institutions hereby, A, irrevocably and exclusively grants to the conference during the term all rights necessary for the conference to perform the contractual obligations of the conference expressly set forth in the ESPN agreement. Here's the most important part. Regardless of whether such member institution remains a member of the conference during the entirety of the term. It's addressed there. It's also addressed in a second part. This is under the acknowledgments, representations, warranties, and covenants within the grant of rights. Again, it says, each of the member institutions acknowledges that the grant of rights during the entire term is irrevocable and effective until the end of the term, regardless of whether the member institution withdraws from the conference during the term or otherwise ceases to participate as a member of the conference in accordance with the conference's constitution and bylaws. It's very clear here that they're giving it during the entire term of the grant of rights. Can you parse that? Can attorneys argue against that? Absolutely they can. But when I read that, it's pretty clear to me that they are granting their rights for the term of the grant of rights. Now, push back on me if you disagree, Steve.
I don't know that I necessarily need to push back or even disagree, other than just to say it's because I've read differing opinions on this from attorneys that will make good arguments either way. I've seen people argue that even though it says the entire term, that basically when they leave, that the future games no longer belong to them, but what they meant was the entire game is those past games that were already played still belong to them, kind of like we were talking about with the PAC and owning the historic games. And I've seen people argue that. We'll see what Florida State argues, how they argue it, going forward. I'm not going to necessarily push back on what you're saying, because a lot of the language does definitely seems very clear, but they're making an effort to tear this apart, and we'll see. And again, a lot of this will come down to the interpretation of a judge and how they interpret not only exactly, it's not always exactly about the language of a contract, but how contract law is applied in different states. And that's why, again, the Florida State, they want this in the state of Florida, and the ACC, they want the interpretation to be done in the state of North Carolina. Yeah. I think both sides feel they have some openings, not necessarily because of the language in the contract, but because how these laws are applied differently in the different states.
And I want to give, I've heard arguments to your point about they're only talking about while they're a member, and the term is while they're a member. Although what I just read, I think, is clear that it's the term of the agreement. But let me put the shoe on the other foot real quick, and certainly our viewers can disagree with me, and I'm sure many will, and that's fine. But you got to understand the grant of rights. All of these schools are agreeing to a grant of rights for a term, so that they, the ACC, the commissioner of the ACC, we talked about that, have the ability to have a product, what did they call it? To have property in order to sell to an ESPN, Fox, or whatever. It's not well, here's something, but they can leave whenever. I don't know if I'm going to have an FSU 2 years from now. The term is the in full agreement, so they have something to sell to ESPN. So I'm not saying that's the right or wrong interpretation. It's just another interpretation that to me makes sense. Like you're giving your rights for the term of this agreement so they can be sold or marketed and then be sold to the highest bidder.
Yep.
So again, I get it. You're going to have people differing on that. They're going to have difference of opinion on that. But those are things that we've talked about in some past episodes in terms of the grant of rights. I overall think FSU has some much stronger arguments than anything that we've talked about here. Again, this is all about staying discovery.
Yes.
So they're just trying to poke holes in this mischief. That's why they lay out mischief and why they call it that, because they're saying you can't stay discovery. We need these documents to build our case. So you got to make sure you're looking at this under that purview. Now, anything with that before I go to the motion to seal?
No, let's keep going.
So the motion to seal in Florida, I just want to slow this down a little bit because we got a lot of comments, several really good commenters. I mean, we didn't agree, but I had some back and forth with the comments, and they were just asking questions, and as long as we're respectful, I love the dialogue. Yeah. I'm not necessarily right, or you're not right, but let's have the dialogue. You can show me to think about something a different way. But I think we have to slow down here a little bit and realize we have to go from point A to B to C to D, and I think people want to go from A to D, right? A is where we are now, and don't seal it because we've got the Florida Sunshine Laws back here at D. But let me kind of lay out that process just a little bit more. And you know, we got to follow the rules. As FSU said in the hearing, we have to follow the rules here. And like I said, I talked to our in-house counsel. I wanted to be clear on really what this would look like. I thought I knew. He kind of confirmed what I was thinking. Again, he's a contract attorney here. So just lay this out real quick. I think, again, this is going to be sealed for now in North Carolina. So what does that mean? Well, it's sealed for now until we get to, and I'm going to stay with North Carolina for a minute, until we get to another hearing, a case, discovery in that. And at that point, it's likely that the seal will be taken off of this, but then it'll be put into discovery with some sort of protective order. Again, I'm talking about North Carolina. Some sort of protective order, meaning it's not just going to be open to the public. Yes, the attorneys are both going to get it. Yes, the judge is going to get it. But there's going to be a protective order to keep things that are trade secrets. Don't argue that with me. Just hear me out for a minute. Trade secrets under this protective order. Then we'll go through the discovery process. If it gets to a hearing, some of that protection may have to come off so that it can actually be heard correctly in a court of law. And, you know, again, that doesn't mean it becomes a public document in North Carolina, but it's certainly not sealed anymore either, right? So there's a process to go through.
And I've seen some examples. I was just kind of researching for our last video where we did the deep dive in the North Carolina hearing where protective orders can be. I just saw some examples where basically the judge sees the information.
Absolutely.
They can see everything. They just don't put it on the public docket and maybe don't read from it or show excerpts on the board while the court is in a public session. Now, in that business court, there's not a jury.
Right.
It's just the judge deciding. But I saw some examples of a protection order like that, and where the judge can read through it and make a determination before it gets put on the public docket and put out the public domain.
And we saw that earlier. So according to FSU, they said, hey, the ACC didn't provide the definition of this, and it's apparently defined. And the judge said, you need to please provide that for me. And they did. They have to. You can't withhold that from the judge.
Right.
The judge can see whatever he wants to see. He asked for, and this is just one part that we know he asked for. I would guess there's probably more. They've got to turn that over to him.
Right.
And it's protected through him. So let's get to Florida real quick. I mean, we may get the same process in Florida, but then a court says, no, there's no seal here. This is a public record. Now, the question that we're going to get into, and I don't mean to get into it now, but if there's a seal put on in North Carolina, for an example, can a Florida court kind of overrule that because it's under that Florida statute? I would think the answer is yes, but I don't know for sure.
From what I understand, the ACC has, unless there's something new, and you can correct me, the ACC has not made a motion to seal in the state of Florida.
Correct, right.
So, you know, if the case in Florida moves forward and all of this stuff is put into the public evidence, public domain via discovery, then it might basically become a moot point anyways.
Absolutely. It would be. For sure it would be. But we'll see. I also want to remind everyone, I talked about the Florida AG Moody. I had requested information from them regarding the documents that she requested from the ACC. She did that back in early January. Here we sit, the end of March. Well, heck, April 1st when this sucker comes out. So almost 3 months later, right? No, 4 months. January, February, March. No, 3 months later.
Yeah.
And I said, hey, I just want to know, is this still open and active, or has this been rescinded, withdrawn? Because I did see some rumorings that it had been withdrawn.
I saw some people on Twitter say point blank it was withdrawn.
Well,
I don't know where they got that.
So I have an email.
Yeah.
I'm not going to put it on the screen, but you can either trust me or you don't have to. It doesn't really matter to me. I know the email that I got.
I saw it
from the Florida AG's office through their. I worked with their media. I don't know who it was. Media PR person. And it was a simple question, Steve. It took them 2 weeks to get back to me on a simple question of, is it still opened or has it been rescinded? According to them, it is still opened. So I just say, wow, it's been 3 months for the sunniest of all sunshine laws, and she hasn't pushed this at all ever since. There's got to be something there why she hasn't pushed this any further. I actually am not even 100% sure if I believe this guy. I mean, I hate to say that, but like, it took him 2 weeks, and he responded. Finally, when I pushed him a third time, I got a response very quickly, and it was just like, yeah, no, it's opened. That was it.
I'm gonna speculate a little bit here.
Okay.
I kind of feel like the AG and the governor's office and all the power players involved in the state of Florida, I've been kind of confused, perplexed as to why they have not been waded into this more forcefully.
Yeah.
And I'm just kind of, as speculation, I'm just going to say maybe they're just waiting until this April 9th hearing just to kind of see where things go, keeping their powder dry. They don't want to wade in too much. They want to kind of let these things run its course. That's just speculation by me. And so, the AG, maybe she got out a little ahead of herself. Yeah. I want these, whatever. And then maybe, well, let's just let this play out in this court. We don't want to look like we're interfering in a case if we don't have to.
Right.
If we can get a favorable ruling without doing that.
And for all we know, it could have been the FSU lawyers being like, whoa, slow down a minute. Let us game plan this. Let us handle this.
Right.
We know where we're headed. Right. Don't, like to your point, maybe she would end up doing something that would hurt a case for them moving forward in whichever way they want to maneuver. So that's fair enough. Last thing I'm just going to say is, documents will be handed over in discovery. They will be. I think everyone's getting all worked up about this seal right now. It's really not a big issue. Whether it happens or not, we think it's going to happen. But once it gets in discovery, certainly if we ever get to a hearing, this stuff's going to be there under protective order, likely, but the judge will see it. FSU's going to see everything they need to see. We all people getting really, really excited about this right now.
And I think, honestly, Florida State fans are kind of up in arms about it because the FSU legal team is pushing this so hard. They want these documents out. They want them in the sunshine. The sunshine is the best disinfectant. To put the cheating mischief of the ACC out there for everybody to see. Yeah. So they're pushing that, and so the Florida State fans are like, yeah, that sounds great to me. Let's put it out there. So like you said, it's going to come. There's going to be a process. I think. We've laid out the process in North Carolina, the precedent in this business court for this judge. I think it's pretty clear how he likes to operate.
Yes.
And the ACC lawyers knew exactly his precedent, how he likes to operate, and they're trying to follow his path. So we'll see what happens there. Could be a total different situation in the state of Florida. We may have competing cases going on in two different directions there. We'll see. So I'm going to say I think that's why the FSU fans are so up in arms about this is because the FSU lawyers are pushing this. So but I think we're going to have some answers here pretty soon in the next week or so.
Yep. And that's a great segue to end this sucker out. We're going to start focusing on hearings at this point. I think some of these, I called them pissing matches the last time, between he said, she said type
dueling
of stuff.
Filings.
Dueling filings. It's too much. Unless there's something that's really, really interesting in these that we haven't covered before. It's just reading things differently and them trying to, take a position, obviously, that's counter to the other position. So we're hopeful maybe by the end of this week we hear from our good buddy Judge Bledsoe in North Carolina. He said he'd have it before the 9th. Believe it or not, the 9th is only a week and a day away, so we're going to be covering the hearing and things that come out of Florida as well. But with that, we're probably not going to do too much of these filings pissing match back and forth. We're ready for hearings. Let's do this.
I'm ready for some decisions.
Decisions, absolutely. Yeah. So, hey, with that, we thank you guys for watching. Make sure you give this one a like, subscribe if you like our content. We'll see you next time on the Big Mountain.